Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 78. The first question, of course, is, did you miss me? You may not know, but I've been away for 6 weeks, and the podcasts that have appeared in the last couple of weeks were episodes I recorded before I went away. I was lucky enough to negotiate an extended 6-week holiday from the firm. So as a reward for sticking with this podcast to the end, I will be happy to share with you a couple of the things that happened on my way round, because basically I had a fantastic time. Anyway, let's do business first. In the podcast, we're going to be looking at 3 recently recorded cases. The first is an ECJ decision in relation to working time. Now, this has got quite a lot of publicity, and the key focus in the case is about mobile workers with no fixed place of work and whether they can count their first and last journeys to and from their homes to work each day as working time. Secondly, we've got an EAT case which considers whether a permanently incapacitated employee was assigned to a particular business for the purpose of a duty transfer. And finally, and this is another EAT decision, this time it relates to a disciplinary investigation that came under challenge because of the influence the HR team appear to have had on the final decision to dismiss the employee. And of the 3 cases, I think the one that's going to have the most impact, it's that last one. And I'll explain why I think it's potentially quite a troublesome case, and one that all HR departments, ER advisors and so on really need to know about. So let's start. So the first case is something unpronounceable. I'm going to call it the Tyco Integrated Security case because the remainder of the case title, it's a Spanish title, and I would butcher the Spanish language if I tried to pronounce it. But if you look up Tyco Integrated Security, that will give you links to the case. Oh, I should say, of course, in the usual way, the podcast will continue to be available on YouTube, the firm's intranet, and on Twitter. We will post links to the cases that I'm discussing, and I've been contacted by at least one listener to ask about ensuring that the links are provided, so I know that it is of assistance to many people. Well, this is the ECJ case concerning mobile workers who have no fixed place of work, and in that case the European Court has had to consider whether the time spent by such workers travelling between homes and their first and last jobs of the day has to count as working time for the purpose of the Working Time Directive and its various national implementations. A lot of confusion and uncertainty has been generated, and the headlines suggested that the case may be groundbreaking. I intend to explain how in practice it's only likely to have a limited impact on a really pretty small number of employers. By way of background, Article 2 of the Working Time Directive defines working time as, quote, any period during which the worker is A, working, B, at the employer's disposal, or C, carrying out their activities or duties in accordance with national laws and or practices. Article 2 defines rest periods as any period which is not working time. In other words, you're either working time or it's a rest period. And the 2 definitions are mutually exclusive. The Working Time Directive was implemented in the UK by the Working Time Regulations 1998. The regulations provide the average working time for a worker in the UK must not exceed 48 hours per week unless the worker has opted out or another exception applies. Also, workers have to have adequate rest breaks in respect of certain patterns of work. However, regulations of the directive are silent as to whether travel time should be considered as working time. As a result, some employers were unable, or possibly unwilling, to calculate the amount of working time that employees were completing in order to ensure that the 48-hour week restriction wasn't breached without an appropriate opt-out, and also to consider whether adequate rest periods were being achieved. The key question put to the European Court in this case was whether Article 2 should be interpreted so as to classify the time spent by workers who are not assigned to a fixed or habitual place of work and who travel between their homes and the customer's premises at the start of the day as working time under the directive. Facts of the case are very straightforward. Tyco runs a business which involves installing and maintaining security systems. Tyco has around 75 technicians. Each technician in Spain was assigned to a particular area, and in that area there was a regional office which the employees report to on a daily basis. In 2011, Tyco closed the regional offices and the employees were assigned to a central Madrid office. Before the regional offices were closed, employees calculated their working time from the point at which they arrived at the regional office to pick up their company car until they arrived back at the office at the end of the day to drop off the car. As a result, their first journey from the office to the customer's premises and the last journey from the customer's premises back to the office were considered working time for the purpose of the directive and accepted as such by Tyco. However, after the closure of the regional offices, technicians would simply use the company car to travel to and from their homes to the customer's premises. Tyco made it clear it did not regard these first and last journeys as working time. Rather, Tyco calculated their working day as starting from the arrival of the technician at their first assignment and ending when they left that assignment. Employees challenged this decision, and as I mentioned, the key point was whether the technician's travel time on their first and last journeys directly to customer premises should count as working time. Well, the ECJ found the travel time did constitute working time under the directive. In finding this, the court emphasised the fact that prior to the regional closures, Tyco had characterised the journeys between the regional office and the customer's premises as working time. The ECJ held that the nature of those journeys, in comparison to those between the employee's home and the customer's premises, were no different. In addition, the court found the employees had to obey the employer's instructions and were required to pursue the employer's interests and not their own interests during those journeys. The workers acted on the instructions of the employer, who could change the order in which the customers had to be seen, and they could cancel or add appointments at the employer's discretion. In essence, workers were not able to use their time freely during the relevant periods of travel. As such, they were at the employer's disposal, and so satisfied the test for working time under the directive. Well, pausing there for a moment, the key concern that appears to have arisen as a result of the judgment is that UK employers may have to review the practices of their mobile workers and in some cases reduce their hours to ensure they have sufficient rest periods during the day and they don't trip the 48-hour working week restriction. But as I mentioned earlier, whilst this case has sparked much conversation, I think it has a much more limited impact. First, the case is very fact-specific. I think the fact that Tyco changed its approach in relation to these journeys after the closure of the regional offices was a factor that the ECJ took into account when finding in favour of the employees. Secondly, the case will only affect employees of the mobile workforce with no fixed initial or final place of work. Thirdly, the case won't have an impact on employers in the UK, where the individual affected has opted out of the 48-hour working week limit. And in addition, of course, it's unlikely that if an employer doesn't have a 48-hour opt-out in place, the journeys at the start and the end of each day would be so great in duration, they'd tip many employees over that 48-hour working week limitation. Equally, to the extent that rest breaks and so on occur later on during the day, I think it's unlikely that the addition of the travel time is going to make things radically different. Finally, the judgment, and this is key, does not require employers to pay employees for this additional working time. The Working Time Directive does not state how much money workers have to be paid for their working time. That is left, under English law at least, to the national minimum wage regulations. Those regulations include an express carve-out which makes clear that a minimum wage is not required to be paid for periods where workers are travelling between their home and their place of work. Therefore, even if you were an employer who employed mobile workers, you didn't have a 48-hour opt-out in place, and you had a workforce that travelled enough hours a week in order to trip the 48-hour restriction, there's nothing under UK law that actually requires you to pay your employees any more money for that extra working time. Of course, it's possible the UK government may change the national minimum wage regulations to provide that such time travelling should attract remuneration, but you may take the view that's pretty unlikely in the current climate. So, that's the Tyco case and working time issues, which I think are of relatively limited application to UK employers. Second case, BT Managed Services Limited and Edwards and another. Well, this is an EAT decision concerning an employee on long-term sick leave and whether he was assigned to an organised grouping of employees transferring under TUPE. TUPE applies to automatically transfer employees where there's a business sale or a service provision change. In circumstances where there's a service provision change, for example, where services have been taken in-house, outsourced or transferred to a new provider, the employees who form an organised grouping with the principal purpose of carrying out the services will transfer automatically to the new provider. And obviously the critical question is, which employees will transfer. Not always clear-cut. There have been a number of cases over the years, and we've indeed talked about some of them on the podcast before. But there are a number of considerations. The age-old question of whether a particular employee is assigned, the relevant test, is assigned to the transferring services so that they will transfer under TUPE, is made rather more complicated where that employee, at the point of the transfer, is on long-term sick leave. And you wouldn't believe how often this actually comes up in practice with the transactions that we're dealing with. Helpfully, the EAT has recently handed down a decision that considers almost this very scenario. I'll explain the almost in a second, and has provided some useful guidance on how to treat an employee who is permanently absent on long-term sick leave at the point of the TUPE transfer. Well, key facts of the case were that Mr. Edwards had been assigned to a particular contract for maintenance services that BT operated for Orange. However, he was absent on long-term sick leave, and ultimately, after unsuccessful attempts to return to work, he was deemed permanently unfit to work. He remained an employee in order to receive payments under BT's PHI policy, and then, when the PHI cover ran out, he continued to remain an employee of BT's, and he continued to receive sick pay from BT itself. However, he carried out no further work for BT, and there was no expectation he would be able to do so in the future. Orange subsequently re-tendered for BT's service contract, and the contract was awarded instead to Ericsson. Ericsson and BT agreed there was a service provision change under TUPE. Mr. Edwards' colleagues, who were assigned to the BT contract, transferred from BT to Ericsson. However, Ericsson refused to take on Mr. Edwards, who had been on long-term sick leave at this point for about 5 years. Ericsson argued that Mr. Edwards was no longer assigned to the organised grouping of employees that performed the transferring services. As such, they said, TUPE didn't automatically transfer him to Ericsson. And this is obviously here quite an important point, and financially sensitive, given that the payment obligation was directly on whoever was the employer, and it was no longer being covered by an insurance company. The employment tribunal, agreed with Ericsson, concluded that Mr. Edwards was not assigned to the organised grouping of employees carrying out the services. The tribunal held that Mr. Edwards ceased to be assigned to the organised grouping when BT's managers decided that he was permanently incapacitated and had no prospect of returning to work in the future. Therefore, the only link between Mr. Edwards and the organised grouping was historic, and only continued for the administrative purpose of paying him PHI, and then, subsequently, company sick pay. BT appealed to the AT. The AT rejected the appeal, concluding that Mr. Edwards did not transfer under TUPE to Ericsson, but instead remained employed by BT. Although Mr. Edwards would have been part of the organised grouping had he been fit to return to work, the key fact here was that a decision had been made by BT that he was permanently unable to return to work on account of his sickness. As such, he was unable to be actually involved in the economic activity carried out by the grouping. The EAT concluded that some level of economic participation, or in the case of an absent employee, an expectation of future participation in carrying out the activities, which are the main purpose of the organised grouping, is necessary for an employee to be assigned to that grouping. The EAT agreed with the tribunal that, quote, something more than a mere administrative or historical connection is required, unquote. And here, Mr. Edwards' links were historical and administrative only. The EAT also noted that, quote, permanent inability should be distinguished from temporary inability, unquote, when deciding whether an absent employee should be assigned to an organised grouping for TUPE. On this basis, the EAT distinguished this case from employees on maternity leave or long-term sick leave where a return to work is anticipated, and there is therefore an expectation of future participation in carrying out the activities of the group. So, well, the decision was clearly very fact-specific. Mr. Edwards' permanent inability to return to work and the fact that BT made a conscious decision to keep him permanently absent on sick pay were key to the decision. As such, the decision provides guidance on how to deal with this very limited group of employees. But it is of significant practical importance to get the decision right about whether or not an employee on sick leave transfers. To get it wrong exposes transferor or transferee to a potential disability discrimination claim if the employee in question can show that he or she was treated differently to other employees in the grouping because of their long-term absence, which is very likely to be a disability. Unfortunately, following the judgment, it isn't entirely clear where the boundaries lie for determining whether an employee should be labelled as permanently off-sick rather than off-sick on a temporary basis. This is ultimately going to be a question of fact, and the transferor and transferee should flesh out these facts in negotiations and I would suggest reflect them in the terms of the business transfer. Therefore, the due diligence process is going to be used by both parties to gain an understanding of which employees are off on long-term sick and details of their expected return. Following this case, I'd suggest it's also prudent to consider that any employee on long-term sick will transfer if there's any likelihood of that employee returning to work in the near future or the longer-term future. By analogy, if an employee is undergoing a disciplinary process or an appeal against a dismissal that is outstanding at the point of the TUPE transfer, they will be deemed to transfer once the outcome of the disciplinary process is decided, assuming they remain an employee. And there are cases where employees were dismissed ahead of transfer, then the appeal was upheld, and that restated the employee's contract, which then transferred across. So I think this case is consistent with that in some circumstances, even if you're not actively in the business, you can still be assigned. But if the link is historic and administrative only, you won't be assigned. So, in summary, I think it's unlikely the tribunals are going to want to start quantifying the percentage chance of an employee returning to work from long-term sick leave in order to decide whether or not there is a TUPE transfer. It is important that both transferee and transferor have an understanding about the employee's expected return to work with the business, because this is going to determine whether the individual transfers or not, assuming they would otherwise be assigned to the business. So that's BT Managed Services Limited and Edwards. Now, third and last, and with all due respect, as they say, my least favourite case of the week, Rampal, REMPHAL, and Department of Transport. This EAT decision focuses on the apparent improper influence that the Department of Transport's HR team had in relation to a disciplinary procedure which ended in the dismissal of an employee, Mr. Rampal. I think the decision is a pretty troubling and slightly confused one, and I think it's going to give HR departments and employers generally a headache until the position is clarified. I should make it clear up front, in any summary I give of the case, this case is still continuing. The Employment Tribunal has been asked to reconsider certain questions, and so the points are very much in play, and findings of fact may well be changed. Anyway, according to the summary, the case concerned a disciplinary investigation and hearing that took place by the Department for Transport into alleged misconduct by Mr. Rampal. The disciplinary procedure focused on the apparent fraudulent expenses claims submitted by him and his apparent misuse of hire cars. A manager for the Department of Transport, Mr. Goodchild, was appointed to carry out the investigation. He was inexperienced in concluding disciplinary investigations and hearings, and so, as you'd expect, he got help. He sought help and he got help from the HR team. A couple of weeks after the disciplinary hearing, he sent the first draft of his report to the HR team. Whilst the report was relatively critical of Mr. Rampal, it also contained a number of positive findings in his favour. For example, Mr. Goodchild's draft report said he did not consider that Mr. Rampal's misuse of hire cars was deliberate, and he had also found that some of the explanations given for the expenses were plausible. Taking all of that into account, Mr. Goodchild initially recommended there should be a finding of misconduct against Mr. Rampal, and the sanction should be a final written warning. Following Mr. Goodchild's draft report, there were extensive communications between Mr. Goodchild and the HR team, which spanned a whole 6 months. During this time, there were a number of drafts circulated and a number of changes made to the report. The key changes included the removal of the positive findings about Mr. Rampal's conduct, and the finding was increased from misconduct to gross misconduct, and the sanction was increased from a final written warning to dismissal. As such, after he was dismissed, Mr. Rampal brought a claim for unfair dismissal. At this stage of the Employment Tribunal, the tribunal judge found the disciplinary investigation had been reasonable, and the decision to dismiss fell within the band of reasonable responses. Mr. Goodchild, in giving evidence, was, quote, adamant, unquote, that the final decision was his. He'd not been told what to do by HR. On that basis, the tribunal said Mr. Rampal's claim for unfair dismissal failed, but he appealed. And what do you know? The EAT allowed the appeal. Now, for reasons I'm going to explain, the decision, although apparently a relatively simple one, is actually quite difficult to follow in a couple of parts, and this is one of my major concerns about the case. Anyway, the outcome was that the EAT judge remitted the matter to the same Employment Tribunal judge to reconsider whether the influence of HR was improper, and if so, whether it had a material effect on the ultimate decision of Mr. Goodchild in relation to his culpability and the penalty of dismissal for gross negligence. So why do I find the case to be a confusing one? Well, on the one hand, it is possible to read the case and the decision in the case as indicating the employment judge had failed to deal adequately with an argument put forward by the claimant at the employment tribunal stage. The argument was put forward by the claimant there had been improper influencing of the decision, and the EAT, at first glance, found simply that the tribunal judge had not dealt with this argument properly. I have to say, I think this is pretty tough on the employment judge, given that he did consider the argument and, to read a summary of the employment tribunal decision, did explain why he didn't accept the point. And if that was the main point of the EAT's decision, it would have been of relatively little impact. It's true, there had been something like 6 months between the initial draft report and the final decision, and clearly there had been significant rewriting of the report in the meantime. However, the problem I fear is that there is an alternative reading of this case, and that's what's going to get picked up. The employment judge makes a number of almost policy statements about their interaction between HR and an investigating or disciplining manager in a disciplinary process, which seem to go really beyond the ambit of what was necessary to decide this case. Let me explain. The judge makes comments which are going to be seized on by claimants, and HR are going to have to address comments like this. Quote, "If the integrity of the final decision to dismiss has been influenced by persons outside the procedure, it, in my opinion, will be unfair, all the more so if the claimant has no knowledge of it. And, quote, I consider that an employee facing disciplinary charges and a dismissal procedure is entitled to assume that the decision will be taken by the appropriate officer without having been lobbied by other parties as to the findings he could make as to culpability, and that he, that's the employee, should be given notice of any changes in the case he would have had to meet so that he can deal with them, and also given notice of representations made by others to the dismissing officer that go beyond legal advice and advice on matters of process and procedure." Well, that's pretty powerful stuff, and read literally sets high standards for employers, or maybe low traps. An advisor's role is to be limited to policy and procedural matters and possibly consistency, i.e. information about past treatment of similar offences. But I think these generalised pronouncements go beyond the current state of the law and, moreover, don't then seem to get followed up in the final decision of the EAT judge. At the end of the day, the EAT remitted the matter back to the employment tribunal to consider the argument raised by the employee. This is despite the fact that the EAT had reams of written evidence relating to HR's involvement in the original process. Indeed, the successful claimant's barrister made precisely this point, and asked the EAT to substitute a finding of unfair dismissal rather than remit the matter back to the employment tribunal judge. And the EAT refused to do this. It said the matter should go back to the judge. In other words, the EAT didn't say it was necessarily unfair for HR to have done the things they had done on paper. The EAT had based its decision on an earlier Supreme Court decision called Chabra and West London Mental Health. And that earlier case, the Supreme Court case, made a very sensible point that an investigator's report needed to be the product of the investigator. I don't think anyone would dispute the fact that if you appoint an investigator to look into issues, but someone else actually writes the report or takes the key decisions, that would be unfair. What is an issue here is the extent to which the investigator can ask for advice or assistance and take those points on board in coming to his or her own decision, i.e. creating his or her own product. I think it's here that the EAT may overstep the mark, with all due respect, and its pronouncements go further than the case required them to go, but also at the moment are unsupported by authority, even if one agrees with them as a matter of principle. Let me give you an example. Imagine the investigator produces a draft of the report, shows it to the HR advisor, and the HR advisor says the report doesn't make sense, it's illogical, it's irrational, it fails to take into account the seriousness of the misconduct charges faced. If HR make those points but the investigator ignores them, there's no problem, surely. HR would possibly have gone beyond its role, but it would have had no impact. Similarly, if HR make points and the investigator looks at them, accepts them, and adjusts his report accordingly, is it really intended that he has to disclose the substance of the exchange to the employee and invite the employee's comments on whether or not it is permissible for him to develop his thinking? It's to be hoped, I think, that either this case gets appealed, although on the narrow reading that will probably serve no purpose, and so these pronouncements get knocked back, or the employment judge possibly stands by his earlier decision, which after all did consider this point to extent, and decides that at the end of the day the product was the product of the original investigator, notwithstanding the comments from HR. Well, what's to be done about the decision? Well, if things don't change, I'd suggest the employers should immediately introduce procedures along the following lines. HR needs to be aware that, to the extent that their advice, whether requested or offered, goes beyond policy, procedure and consistency matters, there is a significant danger that it will be seized upon in a claim for unfair dismissal. Investigators and decision makers need to own their own decisions. We've certainly seen plenty of cases where HR or legal were providing advice to a disciplining manager, but the disciplining manager, when subject to question in perhaps a subsequent tribunal case, is saying things like, I was advised to dismiss. That's going to be deeply unhelpful from now on. Advice that goes beyond policy and consistency should probably be provided by a lawyer, since it would almost certainly be covered by legal professional privilege. Of course, to the extent there are to be discussions going beyond policy and procedure, it may be better that these are in discussion form rather than document form. And certainly I think one should be very wary about creating revised drafts of reports or decisions where the earlier draft is going to be disclosed. Obviously, as well, it's likely that decision makers and investigators are going to be asked about advice they took and from whom. In an ideal world, an advisor will be able to advise whilst the investigation or dismissal process is going on to ensure that the whole thing stays on the right side of the line. But if you're coming into a tribunal hearing after the initial decision to dismiss or discipline has been made, it's certainly something as an internal external advisor you're going to want to know what conversations had, what advice was sought, so that you're able to plan the appropriate response. So overall, I think this is a troubling decision, and I think the pronouncements by the judge maybe go further than the decision, and it's the pronouncements that are going to cause problems for employers. So that's the case of Rampower and Department for Transport. I said at the start of this I'd say a few words about my trip. I spent a couple of weeks out in Italy, which was fantastic fun, and then I did a 2-week fly drive holiday on my own, starting in Nashville, and went from Nashville to Memphis, and then worked my way down through to Louisiana and New Orleans, staying at sort of Clarksdale and places. Basically had a fantastic time. And in terms of highlights, well, in that old cliche, too many to mention, but if forced, I'd probably say ending up as a guest, an impromptu guest on America's longest-running musical radio show, which was entertaining, playing the piano for a tour party, and playing the piano very badly, I should add, for a tour party in a southern plantation mansion, and listening to more music of varieties, country and western, blues, New Orleans trad jazz, etc., listening to more music, I think, in a 2-week period than I'd ever listened to in any other 2-week period of my life. So, if anyone's thinking of doing a trip, Nashville to New Orleans, and wants some travel advice, please feel free. It's all part of the service, and I'd be delighted to provide advice and assistance and thoughts about things to see and do, because I had a fantastic time. So, with all that said, it only remains for me to say thank you very much for listening, to confirm that no employees were harmed or otherwise mistreated in the making of this podcast, and to say business as usual. Speak to you again in 2 weeks' time. Take care, all.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.